We've talked about how the United States Court of Appeals for the Fourth Circuit, which is overseeing the Bianchi versus Brown case dealing with Maryland's quote-unquote assault weapon ban, is utterly anti-gun and activist. So they're the worst kinds of judges. Not only are they bad judges in interpreting the Constitution, they're also aggressively partisan against the Second Amendment. That's the worst combination. So I want to play for you some of the comments and discussions by the judges themselves, because I think you need to hear what these judges are saying. And I think when you hear what they're saying, you will think to yourself that you are indeed smarter and better on these issues than they are. So when I say to you, I will make you smarter than anyone else in the room, including judges, I'd like to think that what I'm about to play for you will illustrate and demonstrate that I am accurate on that goal and prediction. Okay? Well, let's see what happens when we get right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of many books, including Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. New book coming out very, very soon. All right, folks. So you viewers here in the Four Boxes Diner know very well that the Bianchi case out in Maryland is in front of the United States Court of Appeals for the Fourth Circuit en banc. That's because this en banc court wanted to make sure that a three-judge panel that heard oral argument on this case at the end of 2022, they pulled this case away from this three-judge panel, almost certainly because that three-judge panel was going to rule in favor of the Second Amendment and declare that Maryland's quote-unquote assault weapon ban was unconstitutional under the Second Amendment, to make sure that that embarrassing event, i.e. upholding the Second Amendment, did not occur in the Fourth Circuit, which is a deep state court of appeals that touches fingers. It's over Maryland, Virginia, right, and West Virginia, and certainly right there outside the Beltway, known for being pro-government, deep state. Department of Justice used to like to try death penalty cases in that court of appeals or in that circuit area because they were pro-government. So anyway, with that said, I want to play for you some of the back and forth of some of the actual events that occurred during the argument, which I covered a few days ago, in the Bianchi versus Brown case dealing with Maryland's quote-unquote assault weapon ban, because I want you to hear some of the comments made by those judges and to understand just obviously how flawed they are. And again, when I say that I want to make you, viewers of the Four Boxes Diner, even if you're not lawyers, smarter than other people in the room, including lawyers and judges, on the topic of the Second Amendment, I really mean it. I think I can get you there. And when you listen to what these judges say, these lifetime appointed federal judges on the Court of Appeals are talking about and saying about the Second Amendment, I think maybe you will realize that when I say I'm going to make you the smartest person in the room, I think I could actually get that done, even if you have Court of Appeals judges in the room with you. All right, so let's just start with the opening statement by Mr. Bianchi, the Second Amendment plaintiffs. That's the Second Amendment Foundation, Firearms Policy Coalition, and all the other plaintiffs in the case. Let's just hear the quick opening statement in support of the Second Amendment and why Maryland's quote-unquote assault weapon ban of semi-automatic rifles is unconstitutional. Let's start with this quick opening statement right now.
Under Heller and Bruin, this should be a straightforward case. Those cases hold that the government can only ban firearms that are dangerous and unusual. And here, Maryland bans the most popular rifles in the nation. That law cannot possibly be squared with Heller and Bruin and is therefore unconstitutional.
Now, this is the most absurd argument that you can hear out there. This is a terrible judge. This is Judge Harvey Wilkinson. He is a quote-unquote conservative judge, but he's terrible. He's terrible. He's past his prime. He probably shouldn't be on the bench, but nevertheless, he's there. And you're going to see why when you hear this meandering question about his days in the Army when he fired an M16. But of course, I don't care and you don't care, and the Constitution doesn't care about what you did when you were a W-2 employee as a soldier for the United States Army. Thank you for your service. But, using a service weapon given to you by the government has nothing to do with privately owned arms by American citizens and not people that work for the Army, who are soldiers for the Army. So I appreciate his service for the country as a soldier, but so what? Has nothing to do with the Second Amendment in this context. Nevertheless, here's an example of Judge Wilkinson talking about his days in the military using an M16. Terrible. But listen to hear what he has to say right here.
Have you ever fired an M16?
Excuse me, Your Honor?
Have you ever fired an M16?
I have not, Your Honor.
Well, I have, and
Yes.
we used them when I was in the Army Reserve, and it was way back, way back.
Yes.
And we took shots at the targets. Whatever we hit, there was nothing left. The kick was so powerful that when the bullet struck the human being, it splintered them into all sorts of different pieces. There was very little left of the human being, and that was a much earlier model of the M16. Since then, it's been perfected and perfected and perfected to an even more lethal weapon than the one that I use. And if we are establishing a precedent that says no matter how dramatic the advance in technology, no matter how lethal the weapon, it's all beyond the state's capacity to regulate in some way. I mean, as the Chief's question posed, where is the limiting principle to all of this? Where does it stop? If this considerable list of weapons, and I don't purport to be familiar with all of them, but I assume the Maryland legislature was, and if it's what can be regulated?
Your Honor, these are not unusually dangerous firearms. If we look at the re-ballistics report that the state cited, these rifles have less than half of the power of M1 Garands, which are expressly accepted.
So pretty straightforward. We all know that the constitutional test, taking the plain text of the Second Amendment, shifting the burden to the government, and then looking at historical analogs to see what laws were on the books at the time of the founding. We all know that was done in an arms ban case. And Heller dealt with whether or not handguns could be banned. They did the same exact Bruin methodology of text first, shift the burden to the government, look at historical analog laws. They then came up with a constitutional test that was sufficient for our side to win, not necessary, i.e. the in common use test, because they said, well, obviously, if an arm is in common use by Americans today, it cannot be banned. There may be other ways to deal and protect arms and whatnot, but certainly when you're dealing with the most basic guns in American society, AR-15s, handguns, magazines that hold more than 10 rounds, these are no-brainer cases clearly within the in-common use test, no matter how many blah, blah, blah. People want to complain about certain things like nuclear weapons and all this other stuff. Okay, well, you can deal with those cases when you get there, but for now, in terms of the types of arms we're trying to protect and should be protected, that it should be a no-brainer, because Heller created the constitutional test that says if Americans are using guns, a particular type of weapon or type of arm that has now turned them into in common use, that they're in common use by Americans for lawful purpose, it's clearly protected. But nevertheless, keep in mind that a few years ago in a case called Kobe versus Hogan, the same anti-gun Fourth Circuit Court of Appeals issued it and basically said that AR-15s are like M16s, and because the Supreme Court said in Heller that M16s and the like can be banned, AR-15s are like M16s, therefore they can be banned. Let's hear one of the judges trying to save the Colby standard to say, oh, well, Colby's still good law, despite the fact that Bruin was issued, Bruin was decided. Let's hear what this judge is trying to get away with by saying that M16s, automatic machine guns, are the same as AR-15s, and the Colby decision from a few years ago that said that is still good law. Turn to the record right now.
Americans have a right.
And if Bruin didn't change Heller and our Colby decision, our primary holding
Yes.
was based on Heller,
Right.
then nothing about our primary holding in Colby has been altered.
That is incorrect, Your Honor. Just as the
How is that incorrect?
The alternative holding in Colby was to apply intermediate. So this is the point of
But
it.
that's
Was
the
to apply
alternative holding.
intermediate
Do you
scrutiny.
agree that the primary holding was not addressed at all in Bruin?
I do not agree with that. Bruin.
Show me where in Bruin Colby's primary holding was mentioned.
At pages 21, pages 32, and pages 47 of Bruin, it said Americans have a right to possess arms that are in common use.
And did it mention Colby?
It didn't mention Colby, but
Okay,
that
so it
undermined
didn't. All right.
undermined the reasoning
Did it mention
of Colby.
M16s and the like,
It
which
did-
are those are quotation marks around from Heller?
Did it mention those?
It didn't mention M16s and the like, but what it clarified was the test. Just as with respect to intermediate scrutiny, it said that every court that had applied intermediate scrutiny had gotten it wrong. We're not changing Heller. We're applying the standard we applied in Heller. And just as it clarified the standard of review, it also clarified the test
in Colby,
for
that was
protected
the
arms.
alternative holding. I mean, I agree with you that the test in the alternative holding was changed in Bruin, but that was not our primary holding.
Well, no, the test was not changed in Bruin. Bruin said that Heller demanded a test rooted in history and tradition. So nothing from Heller changed with respect to the standard of review. So unless you were prepared to say...
And that's the alternative holding in Colby. That's what I'm getting at. The primary
Correct.
holding was not
And I'm saying the
impacted.
primary holding was undermined just as much as the alternative holding. Because
And
the
how-
court
go ahead.
because the court made clear in Bruin that the Second Amendment protects the right to possess arms that are in common use, and in Colby footnote 10 explicitly refused to engage in a common use analysis, the very analysis that Bruin said establishes constitutional protection.
All right, well, obviously the Colby decision was wrong. So was the Bevis decision was wrong in the Seventh Circuit. There's no doubt that these cases will be thrown into the trash heap of history if the Supreme Court takes a case involving an AR-15 ban. That is what has to happen. The Supreme Court's got to step up and spank these lower courts because they're simply on purpose refusing to enforce the Second Amendment because they want you to be a peon, they want you to be a serf. They don't think you're entitled to the same kinds of arms to protect your life and the lives of your loved ones the same way they, through what the U.S. Marshal Service has to protect federal judges. They're upset that they don't want you to have those same protections that they get by virtue of being protected by the U.S. Marshal Service, because I'm guessing the U.S. Marshal Service is not protecting you unless you're a federal judge. But if you're not a federal judge, you're not getting that protection, is my guess. But let's move on. So here we have a federal judge talking literally about how AR-15s fire. Ready for this, folks? 300 rounds a minute. Well, let's hear what he has to say here.
Argued
These
that
are
firearms...
dramatically different weapons that are before us in this case than the handgun statutes and handgun regulations that were at issue in Bruin and Heller. This is a whole jump up. It's a different order of magnitude, is it not?
It is not, Your Honor. These are relatively underpowered rifles. But what's interesting...
Underpowered?
Yes.
An AR-15 can fire 300 rounds a minute.
Well, the
As a
Army says
semi-automatic.
45 to 60 rounds a minute in effective
underpowered.
mode. But in terms of underpowered, in terms of the
AR-15.
power of the...
I mean, there are handguns, and they're used in the military too.
Yeah,
The
correct, Your
pilots
Honor.
of our fighter planes have a handgun with them.
But
But we're talking about M16s and the like, and the AR-15 is the M16.
it is not what the...
It is the M16.
It is not in the constitutionally dispositive sense. What the Supreme Court said in Heller is that
They
M16...
named the M16.
And they said
Justice Scalia
Yes.
said the M16 or the like, and the like.
And the like. And the like
And
was
the like.
firearms
And
that
this is
are
the like.
highly unusual in society at large. And these firearms are the opposite of highly unusual in society at large. And the reason is what in Staples, the Supreme Court 30 years ago said that the line between what has traditionally been a lawful possession and what is not is semi-automatic versus automatic fire. And the reason...
Mr. Patterson.
Well, we all know that the U.S. Army manual says that 40 to 60 rounds with the semi-automatic rifle is about as much as you can get. I'm sure there's some super fast shooters out there, but by and large, if you're a normal, ordinary American with a normal semi-automatic rifle, you're looking at 40 to 60 rounds a minute is probably more accurate, and that just kind of illustrates the point that an AR-15 is not an M16, which of course is the point that the judge here was trying to make. And remember, never forget that under federal law, the definition of a machine gun does not, I repeat, does not talk about the rate of fire. So even if you have a slow firing gun, it's possible that could be an automatic weapon and thus a machine gun. And even if you fire rapidly, semi-automatically, that doesn't turn into a machine gun because rate of fire is not a component of the definition of machine gun under federal law. So whenever you hear people talk about how fast you can shoot or the rate of fire or rapidity of fire or anything like this, totally irrelevant as a matter of law because the definition of machine gun talks about firing rounds automatically without any manual reloading by virtue of a single function of the trigger. Nothing about the speed or rate of fire has anything to do with the definition of machine gun. We saw that a little bit in the Cargill case before the U.S. Supreme Court dealing with bump stocks. Anyway, 300 rounds a minute, obviously absurd, but that's the kind of questions that I think the Second Amendment lawyers are getting, as you just saw there. Now, this is a classic example of what the anti-gun movement tries to do. They don't like the in common use test because they cannot possibly win. Because remember, keep this in mind, the in common use test is very important. The plain text has implicated the burden shifts to the government for a historical analog loss. Because Heller did the historical analog analysis already, it came up with the constitutional test of in common use by Americans for lawful purposes. But the reason why you got to understand that sequencing I just described is as follows. Because the in common use test is a constitutional standard derived from history, what does that mean? It means that because it's derived from history, the analysis occurs at the historical level of the text first, burden shifting, historical analog level or part of the constitutional of the interpretation methodology of the Supreme Court's Heller decision. The reason why that's so important is because the burden is on the government to show, ready? The government has to show, and bears the burden to show, that an arm it's trying to ban is, at a minimum, not in common use. So whenever they try to say that the Second Amendment plaintiffs' lawyers or the Second Amendment advocates or the Second Amendment movement has to prove that a particular arm is in common use, that's completely inaccurate. That is a flaw in legal methodology because, again, the in common use test is derived from history. It comes at the history portion of the text first in history, text first in historical analog law. And because it's part of history, the burden is on the government to meet it, which means the government has to demonstrate that AR-15s are not in common use, that magazines that hold more than 10 rounds in America are not in common use. These are absolutely impossible for them to establish, in the same way that it was impossible for the government to show that handguns were not in common use in the 2008 Heller decision. This is very easy. This is why, of course, the anti-gun movement wants to elevate the in common use test in all fights about the Second Amendment to the plain text to shove the burden on to the back of the Second Amendment plaintiffs. Nevertheless, the judges here are trying to take out and criticize the Supreme Court's decision of the in common use test, but it really doesn't matter what an inferior court judge thinks because they're inferior to the Supreme Court. If the Supreme Court says this is how you do it, you have a duty to do it. That is your job. So nevertheless, here's an example of a judge trying to criticize the Supreme Court's methodology as an excuse to ignore it, but even if a lower court judge doesn't agree with the law as given to him or her by the Supreme Court, it doesn't matter. They still have to follow the law. But here's a classic example where they're trying to talk about bazookas and tactical nuclear weapons, but that's irrelevant, right? And the answer to that is, hey, you know what, Judge? Here's the reality of it. If we have a case dealing with the constitutionality of bazookas or tactical nuclear weapons, we'll have a conversation. But until then, we're talking about AR-15s, we're talking about semi-automatic rifles and magazines that hold more than 10 rounds. That's what I'm going to answer the question on. You want to talk about some hypothetical moot court? Then go have a moot court at the University of Virginia. Or go write a letter to the Supreme Court and complain about the test that Justice Breyer criticized, but they rejected all those criticisms. That is the way I would handle it. Or I might even say, I probably wouldn't say this, although I might, you never know. And of course, I can explain all of this to you, Judge, but I cannot understand it for you. Nevertheless, here's a classic example of an anti-gun judge trying to undercut a constitutional test that they have to follow whether they like it or not. Roll the tape.
So a state could not ban a machine gun, assuming that there had been no federal ban.
If they had been in common use, but they had not. I mean, we had a...
What about a bazooka that used for recreational purposes?
Any firearm that is in common use for lawful purposes.
A tactical nuclear weapon.
A tactical nuclear weapon is, it's a...
So there's no limit. Essentially, once the cat is out of the bag, the Second Amendment trumps all. That's your position.
That's not my position. That is Heller's position and Bruin's position, which says that arms that are in common use are protected, period.
All right, so here's the next question where, a judge is talking about Bruin and the Miller case from the 1930s and how hard it is to figure this out when it's super easy. They just have to apply the constitutional test given to them by Heller, but they don't want to do it. They pretend that Heller's not good law, even though Bruin reaffirmed Heller like 80 times. But you can see how these judges pretend they don't understand. It's so hard, but it's not hard because the Supreme Court already did the work for you and gave you the constitutional test. You simply have to apply it, but they don't want to apply it. Check out this pathetic meandering, oh, I'm so confused, oh, I don't know what I'm doing, wearing my black robe here trying to figure out something that the Supreme Court literally gave me on a silver platter to apply. Check this out. You're not going to believe this one.
Well,
That's the conundrum we're in.
they
What Judge
said,
Niemeyer is pointing out is where the difference lies. If you read Bruin, a case that's dealing with handguns in New York City, and then you think that it took care of everything in Miller that dealt with sawed-off shotguns and Heller, then yeah, you'll get there. You will skip right over that first step and go into the historical aspect of it. But Miller made it clear. Miller tried to say, it said to some extent the militia, and then it went into the historical aspect of it, but ultimately Heller clarified Miller. And it said, well, we're not talking about a militia here, because if we do, machine guns are going to be in, that regulation is out the window. But it went on to say that the type of weapon at issue is what is at the point of the Second Amendment protection. And so for that proposition, we look to the Second Amendment to because it does not extend to all weapons. It extends to only certain types of weapons. Now, if you pull from Bruin, from a handgun case, that now every weapon, including machine guns and shotguns, are now off the record, even though we've already said those off, you're going to get there. You're going to get exactly where Judge Niemeyer is. You're going to slide, and that's going to make it harder and harder, as Judge Wilkinson has alluded to. It's going to make it harder and harder for the states, for governments, for the people to enact rights to protect themselves, because you got to skip over that first. You got to accept a grenade and all kinds, and I won't use that. That's too much of a mass weapon, but machine guns and everything. And then you get into this esoteric analysis on the historical aspect. But it's in step one. And if you get it in step one, which I believe is done here, then you're there. And that's the reason that Kobe is still good law. It may not be binding because an en banc court can always rule against an en banc court, but this court made the pronunciation, and the only part of it that's abrogated by Bruin is the means end test, not the rest of it. It looks all good to me, what we said in Kobe, and it seems like that question is answered here today. We can keep sending it down, as Judge Wilkinson say, and do what Judge Niemeyer wants, is go through every one of these and keep going back and forth on it. But the plain text of it covers this answer at step one. We don't need to go to step two.
yes, Your Honor.
All right, so here's another Judge Wilkinson special, okay? Now, here's his discussion about federalism and state police power. And here is a classic argument in defense of federalism, which is a fair defense in a vacuum, basically saying that Montana can enact laws that are different than New York, and that's why we have states and not one single central government. Now, one can debate the role of federalism, although I totally support it, but when you have this massive multi-trillion-dollar annual budget federal government, one wonders to what degree the powers of the state are out there, but certainly is something I support, and I think certain governors like Governor Abbott and DeSantis and others are picking up on the fact that they better get their state acts together because the federal government is not doing its job, for example, at the border. Nevertheless, what's interesting is this is a classic argument about states' rights, the sort of thing you might have heard from somebody in the Confederacy, during the Civil War, talking about, well, yeah, different states can have different values, so why can't, one state ban guns and have all these restrictions on gun rights and another state doesn't have to do that? Of course, the answer is because we have a federal constitution that applies to every single state. The Second Amendment applies to all Americans, just like the First Amendment. This kind of implication by Judge Wilkinson, who is terrible, absolutely terrible, my opinion, should not be on the bench anymore. He should be gone, but nevertheless, he's still there. It's a lifetime appointment, so he gets to stick around. Nevertheless, check this out and just ask yourself, could you have New York State ban churches? And because hey, if New York wants to ban churches and ban worship, that's okay. And if Florida wants to have churches, that's okay. That's called federalism. And why is that saying, okay, well, we're going to ban the internet in like Montana, but we're going to have the internet in California, right? I mean, obviously this would be absolutely stupid because there's certain fundamental rights that Americans all have, no matter where they are in the country. That is certainly the case with the Bill of Rights, including the Second Amendment. So here you have Judge Wilkinson talking about federalism again and again. The reality is that when you you're dealing with a fundamental national right. It applies everywhere. So one must ask, does Judge Wilkinson need some cheese with this wine I'm about to play for you right now?
One thing that concerns me here is that in my friend Judge Niemeyer, in wanting to remand this case, is drawing the judiciary further and further into the position of that we become the draftsman of a substantive code of firearm regulation. And I'm just not sure that the judiciary, by and large, is a bit process focused. And I'm just not sure that going weapon by weapon and saying, yes, this is regulatable, this is not, whether we have completely taken over a legislative function and are being asked essentially to draft a code of firearms regulation. And the other thing, it seems to me what you're asking as opposed to what your opponents are asking is you're just asking for one state to be allowed to go its own way in ensuring the safety of its citizens. You're not asking for Montana to impose an assault weapons ban. You're not asking for Maryland values to be transported to Montana, but by the same token, Montana values and Montana's challenges shouldn't be imposed and imported into the state of Maryland. I mean, the way our federal system is supposed to work is that each state should be, within reason, able to determine what's best for its own citizens. That's at the heart of the state's police power. Since time immemorial, we talk about the state's ability to ensure the safety and welfare and well-being of its own citizens. And to then say that a state is handcuffed and powerless to respond to these technological innovations that's an extraordinary step, and that is what they're asking. And as I understand it, in the amicus briefs lay this clear, and your brief lays this clear, the historical record here, whether you go back to brass knuckles or whether you go back to Bowie knives or whatever, whenever there's a new danger presented, states have been given some latitude in responding to that. And to start to go to this counter-historical theory is really quite dramatic.
Well, I do want to play you some good news from you. This is a very good argument raised by the Second Amendment lawyer on behalf of the plaintiffs in the case, where he talks about an analogy to the First Amendment. Not bad. I thought this was pretty good, so I'm going to play it for you right now.
Thank you, Your Honor. Just a few points. I'd like to start out on this plain text point. I think a First Amendment analogy could be helpful. If I'm talking about obscenity or fighting words or defamation or something of that nature, that's all speech. That's within the plain text of the First Amendment. But it's within a historical exception that those items aren't protected. It's the same thing here. Heller says all firearms, all bearable arms are armed.
Okay, and last but not least, because I think this is a good explanation of the Second Amendment, it's going to reaffirm things we talk about on this channel all the time. Here's the Second Amendment lawyer on behalf of the plaintiffs in Bianchi, the semi-automatic ban case out of Maryland, talking about how Heller and Bruin protects arms that are in common use. Pretty good analysis, pretty good argument right here, right now.
Absolutely.
Okay. So, Your Honor, a few points there. Heller and Bruin did leave a lot open, but one thing they did not leave open is that arms in common use are absolutely protected, and that it is a feature of the Second Amendment that it keeps up with technological developments. And it would not make sense. Again, the purpose, the right was put in the Constitution was to protect the militia. And again, what Heller said basically is you can look at that purpose as a sanity check. And it would not make any sense to the founders of this nation to say, okay, as firearms technology develops, we're going to deprive our militia of that. That would not make any sense. And there is zero history in this country, they have not pointed to it, of banning new firearms technology. There is zero outside of machine guns. And the issue with machine guns, again, is indiscriminate fire, collateral damage, you can't aim it. And these are the opposite. These are accuracy enhancing feature, and there's no history of banning firearms because they're accurate.
All right, folks, so there you have it. I hope, again, this is helpful for you to hear exactly what these judges sound like, what they say, what we in the Second Amendment movement are up against. So while we have to work hard to try to persuade the judges that are persuadable, there are certain judges out there, it doesn't matter who is arguing or what arguments you make, they simply will not care. They will not respect your right to keep and bear arms. And we do have to recognize that is a material, I'm not saying the majority, but a material part of the federal judiciary. So again, hopefully the Supreme Court steps up and takes the Bianchi case or another semi-automatic rifle case and resolves this, because there's enough of these terrible anti-gun judges in places like the Fourth Circuit, like Judge Wilkinson. We're never going to win, no matter who argues it, no matter what happens. It's just never going to happen. So hopefully, we can find ways around this terrible judging, in my opinion. So there you have it, folks. Hope you learned something here today. Make sure you subscribe and resubscribe. Sometimes people get knocked off. We're trying to get to 150,000 subscribers fast. And again, we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.